Well, here we are again. Welcome, Justice Kagan and Paul Clement, two very distinguished people. I'm not going to introduce them. I think everybody here knows who they are, and if you don't, shame on you, because 11-year-old Margaret, who's given me a question, she does know. So we're going to talk today about the experience of being SG. And what might be fun just here for a moment is, if you have ever worked in the SG's office of the United States Department of Justice in any capacity, would you just sort of raise your hand? Because my guess is we have quite a few people who have. Well, I see a few. And if you were the SG. Okay, just kidding, Seth. So why don't we talk about kind of day one, or the day before day one. And Justice Kagan, I mean, did you know you were going to? How did that happen? How did it happen that you became SG?
Well, it was a bit of a surprise to me. It's sort of a funny story. I was actually being vetted for a different job. I was dean of Harvard Law School at the time, and then President Obama won the election, and some of his people called me, and I thought I was going to become Deputy Attorney General. And then someplace along the way, somebody changed his or her mind, and they called me one day and they said, we know you were being vetted for this other job, but we'd like you to be SG. And I was pretty shocked by it, actually, because
they're different jobs.
They are different jobs. They are different jobs, and my background was not the background that, at least in recent years, has been the background of an SG. So I had never done any appellate advocacy. I mean, I had not been in an appellate courtroom, ever. And everybody's laughing. This clearly strikes them as just amazing, right?
I think it is amazing.
And so I kind of did a double take. I gulped, and I said, I'm not sure you have the right person for this job. I do remember saying this, and they said, no, we really think so. And I said, well, I'm not sure. I have to think about it. And I hung up the phone, and I asked them for a day or two to think about it. And of course, I knew it was a great job in all kinds of ways, but you also have to know whether a great job fits with what you're good at. Right. And so I did. I thought about it for a day or two, and then I have my fairly healthy self-regard
kicked in.
And I thought, okay, I can do that. What's the problem?
I can do that job.
Yeah.
Yeah, after all.
But I had a lot to learn. And the people in the SG's office taught me a lot. I mean, it was such an amazing job to step into cold. There's so many ways that you can make mistakes, but the people in the SG's office really do prevent you from making 90% of them.
So we'll come back to that in a second. How about you, Paul? You had a very boring and thorough preparation for the job, I think. So what was that story?
Well, yeah, my story's different. So because I was the deputy for 3 years before Ted Olson moved on from the top job. And so it wasn't like the beginning of the administration where there's a lot of speculation as to who's going to get the job. And so, my strategy was really just to hope that, nobody got the job for a while and I could just sort of do it on an acting basis, and pretty soon people would just get used to the idea. And then before, a certain point, it would just become kind of a fait accompli. And that's essentially what happened. But you do, if you are in that position, and I think Seth was in a similar position a few years before, you really do just kind of keep your head down and think to yourself, well, I'm going to do this job as long as they let me. And, in a sense, you're hoping that the phone doesn't ring. So it's a very different situation.
But there were one group of people who did get used to you, Paul, and I'm not even sure you know this story or this rumor, but the story I've heard, and I've heard it not from being on the court, so I think I can pass it on. It's not. I heard it before I got to the court, is that the court basically, made it known to the White House and the people in the White House that we think Paul Clement would do an excellent job, because the court had listened to Paul argue for several years by then, for almost 4 years by then. And so I think that the court was really happy that that easy path, happened.
Have you heard that rumor? And what would that mean, the court? I mean,
I think it was just, people really thought that...
Yeah. Kind of informal, like an
informal.
ALI meeting.
Yeah, something like that.
Maybe
one person
Justice
says to another
Scalia
person.
says to, President Bush or something, yeah. Is that...
I had heard the rumor. Whether it's true or not, I don't know. Again, I was just trying to keep my head down.
So let's come back, because it is actually interesting that you didn't have that background, but obviously you had the skill set. And so...
Well, you say obviously, but
Well, you did the job rather well. Of course, they didn't keep you in the job
Yes,
for
that's
that
true.
long.
Who really knew?
And
It was like that.
But I don't think
Let's get her out of there.
Yeah, somehow I don't think that was the story. But what was it about being, perhaps it was being dean at Harvard Law School? What was it that you think did prepare you for the job? And then let's talk about those mistakes that you were about to make.
Well, I don't think being dean helped me on the advocacy part of it at all. It's just two completely different things. But I do think being dean helped me on a big part of the job, which a lot of people don't know about, which is a lot of the SG's office is making decisions about what the government's position in different cases ought to be. And that's often a very complicated process because the government is a big place with lots of competing interests. And I thought that one of the more fun parts of the job was sort of getting everybody around a table and hearing all kinds of different views and trying to figure out what to do. And I remember actually the first big meeting I ran was a meeting where a lot of people were at odds over what the government's position should be in a case. And I think I thought that my job was, in a way being dean prepared me, but in a way it was very different because I think, if that had happened when you're dean, you try to figure out a way to sort of split the difference or find the seam, and nobody should go away feeling as though somebody else had gotten 100%. And so you've tried to think of compromises and all. And at a certain point, I realized, I don't know if it was at that meeting or after that meeting, but I realized pretty quickly in my tenure that, in fact, people really appreciated being listened to. People really appreciated being taken seriously. But in the end, everybody got that it was my decision to make, and everybody was going to be fine with whatever decision I made, even though it gave 100% to one person and 0% to another. So that was really fun. I mean, wouldn't you like that as dean? I think so.
All right. I'd take that. What about you, Paul? How do you know what the government's interest is? It is such a big organization. It's a plaintiff. It's a defendant. It's the recipient of discovery requests. It's a maker of discovery requests. It's a property owner. It's a property taker. I mean, how do you reconcile all those interests?
Well, I mean, you try, and it is a process, and what the justice was referring to, I mean, I do think the skill set of being dean would help in that process, in that room. One of our, and I'm not going to name names, but I've heard one of our illustrious predecessors had the ability to get everybody in the room and make all of them, even the one that got their way, feel really lousy. And I think, I've heard others have had more of the model of making everybody feel like they got due process and were heard. The hardest cases, though, at least I found, were the ones where, because what you're looking for is some combination of where the true interests of the federal government lie and the merits of the position. So, in a lot of cases, it works out pretty well. I mean, at the end of the day, the government really is much more a taker of private property than a takee. And so there are issues like that where the long-term interests of the federal government really are pretty clear. But sometimes you would have a case where you'd have some case that arose under one of the civil rights statutes, and the statute applied to the government as employer, and the civil division would come in and they would say thousands of cases are brought against the federal government under this statute where we're the defendants, so we have to take the employer side of this. And then the folks from the Civil Rights Division would come down the hall and they would say, well, we actually enforce this statute as to most municipalities across the country. And we bring hundreds of cases every year on essentially the other side. So we have to side with the employee in this case. And the process of figuring out where to come down was really devilishly difficult. And I do think, at least in my time, you did try. I mean, if one of the positions was a new litigation position, and the other position had been put into regulation or a manual somewhere, I mean, that was kind of a tiebreaker, and you'd search for those kind of tools to try to make what was a very difficult decision. And I think, as the Justice suggested, the one thing that you maybe had going for you is if you were very thoughtful about it and made clear that there was something of a loose hierarchy and you weren't just throwing darts. For the most part, I think people were respectful of the decision that was ultimately made.
And would they accept the decision, or would they attempt to appeal to higher authority?
Boy, I never had an agency attempt to appeal to higher authority, whether it was the Attorney General or the White House. No, I think everybody, and especially I did try to give people a sense that they had been heard, and once they had their due process, as Paul said, I think everybody just sort of accepted that the SG was the decision maker.
Yeah, I can't say I was quite that successful.
That's because he was in the job longer.
I mean, I did have one or two cases where, and they almost were always cases where the decision on the law was crystal clear, but there was a policy aspect to it that somebody cared very deeply, and somebody in a room would threaten, if you don't do what we want you to do, we're going to get the secretary to call the Attorney General, and you wouldn't say ooh. But and on occasion that would happen, and at least my view was, if I knew that was in the works, I would make sure the Attorney General was well briefed, and nothing much came of those calls. But there were one or two of those calls.
So this is something you've written about, the accretion of decision-making power in the White House over the different departments, and maybe the Justice Department was one of the last to experience this phenomenon without even trying to make a judgment about it. But obviously, the White House counsel position has changed a great deal in the last, let's say, 50 years, from advising the president on which gifts to accept to becoming a kind of a legal policy-making organization that is in some way similar to what the Attorney General and the Justice Department was doing. Same phenomenon around what the government's position will be in, let's just say, extremely high-profile cases. Not the average case, but like something where perhaps even it was a priority for the president of some sort. Do we see that phenomenon? Did you experience it, and how do you deal with that?
Well, I mean, I'm happy to start. When every administration seems like it's a little bit different. I talked to some of my predecessors and successors, and I think the dynamic is a little bit different. I mean, if you have a president who was a lawyer or a constitutional law professor, you might have a slightly different dynamic. If you have a president who was not. In my case, I had a non-lawyer president that at the time I was Solicitor General, and so I think that led to a dynamic where there certainly wasn't a lot of temptation by the president to sort of get everybody in the room and sort of talk doctrine. That didn't happen during Bush 43. And so I kind of felt, though, that when the relationship was working well, it wasn't that there was no communication between the White House and the Justice Department. I didn't think, some people probably would advocate for this, complete silo and no communications. I tend to think that that's a little unrealistic and doesn't entirely explain where the Attorney General's authority comes from. So there has to be some communication, but I always thought that when the system was working well, the communication went from the Justice Department to the White House, typically with the White House counsel as the point of contact. And kind of my rule of thumb was, it wasn't in anybody's interest for the White House counsel or the president or the domestic policy advisor, whoever it was, to read about something in the newspaper. If they found out about some appellate decision that they actually cared about from the front page of the Washington Post and didn't learn that it was coming in advance, I kind of felt like that was a failure of process on our part. But I also felt the way that it should work is that the call should be made from the Justice Department to the White House counsel. They should understand what decision has been made. I mean, not may I, but the decision that's been made and the reasoning behind the decision that's been made. And if there's really a strong belief that that's a mistake, you could have a further discussion. But in my experience, generally, if you made the call and you caught the issue before it was on the pages of the Washington Post and explained what was about to happen, that system worked pretty well.
Yeah, I think there's more commonality than you might think from the way you started the question. I was very lucky, and you'll understand one reason I was very lucky, David, because I had somebody in the White House counsel's office who was your first cousin and my great friend, Dan Meltzer, who was the wisest man in the universe. He was, I would talk to him sometimes. I would call him. I would tell him, here's a heads up on this. Sometimes he would call me and say, here's a heads up on this. Everybody's really in a tailspin about something. But we were able to keep each other informed of things that each of us wanted to know about. But he also, I think, to the extent that there ever was a real desire to get in my business, I think Dan actually did pretty well to make sure it never got to me. And that was a real gift to have had him just kind of doing a lot of the blocking and tackling, which, again, I'm not sure if anybody really wanted to do it, but to the extent anybody did, Dan made sure it didn't happen. Which isn't to say that there is one occasion I can think of where a decision that I had to make, had pretty, I guess there were two that I can think of where decisions went up to the president in some form. And at that point, there are some decisions that are just the president's to make. If he makes them in a way that you can't live with, then you have to say so. But there are also times where it really is the president's call to make. So you hope that that's few and far between. But there are occasions where it really isn't an SG-type decision. It's somebody higher.
So there's this classic problem for the SG, particularly an SG who's new in a new administration, which is whether to maintain the same position as the office is maintained. And sometimes the briefs have already been filed, and the SG may be uncomfortable with the position of a predecessor SG. How do SGs think about that?
Well, I think, at least for me, the office was very clear that you were supposed to think long and hard, and then you were supposed to think long and hard again before you changed anything. And I think that was the right advice that members of the office gave me. I mean, I came in at the beginning of an administration, which was after 8 years of an administration of a different stripe. And so there were a lot of things that I came in and thought, really? They've been doing it that way? I don't think I would want to do it that way. That was, a sort of first reaction. And then, I think, the office has a real culture and a real ethos to it, which I very quickly learned to appreciate. And this was one of the ways I learned to appreciate it, is just, they made clear what the office is supposed to be doing. The office is supposed to be, I think Paul said it a while ago, serving the long-term interests of the United States, not any one president. The credibility of the office in great measure depends on the idea that judges actually believe that that's what you're doing, and it's the right thing to do. That's what you're there for, is to serve the long-term interests of the United States. So I think changing positions is a really big deal that people should hesitate a long time over, which is not to say that it never happens. I actually don't remember any occasions, but I'm sure I changed some positions, and I'm sure every administration changes some positions, but the bar should be high.
Yeah, and I had kind of an interesting dynamic when I came into the office, because I was there at the beginning, and indeed I arrived in the SG's office about 4 months before Ted Olson was confirmed. Because there are many reasons why arguably the best position in all of government and the best position in the SG's office is the Principal Deputy Solicitor General. And one of the reasons it's one of the best positions is because you don't have to get confirmed. And so, so I started on February 20th. So I was there a month into the new administration, and Ted was confirmed, I think, in June or something. And we had, for the first 4 months or so, the acting Solicitor General was Barbara Underwood, who had been the Principal Deputy Solicitor General at the end of the Clinton administration. And, that's something. And it's not that I think, when Barbara took that job, she understood there was a possibility that there could be some positions that would change and that she would have to decide whether she wanted to be a part of that. But I really think that the positions, to the extent they changed at all, changed so much at the margin, not, do you support affirmance or reversal, but maybe how do you answer this question or how do you answer that question, that process was, I think very, very smooth. And Barbara stayed in the position essentially until Ted was confirmed. And then she was a unique situation because she had a career billet at the department, so then she moved back to the U.S. Attorney's Office in the Eastern District of New York. But that just underscores, I think, the fact that was even doable just underscores how much there is that sort of presumption that things are not going to change. And, I think that's one of the great strengths of the argument. And, if both administrations are looking out for the long-term interests of the executive branch, they really shouldn't change that much.
So when you decide you do want to make a change, then is there a right way to tell the court that you're making this change, and that do you feel compelled to explain it, or do you feel, look, we changed our mind, so get over it? You might see this from both sides now. Yeah.
I think you have to be upfront about what you are changing.
Yeah.
And sometimes it's sort of, I'm not sure that saying, why. It's like, it was pretty clear why. So I think the most important thing is just to be honest when you do it.
Yeah, I think they're two slightly different situations. At least they were different in my mind. To me, sort of the ideal way to change a position is not to put the pressure on the SG's office to change the position. The way to change the position, the classic case would be if you're defending the constitutionality of a regulation,
right,
and the new administration doesn't much like the regulation from a policy standpoint, well, then the right answer is to get rid of the regulation and promulgate a new regulation, and then the SG can defend that one.
Yeah.
And it's a different one. So have you changed your position? Sure. But the entity in the executive branch that should take the heat for changing the position, the Secretary of fill in the blank, is the one that takes the heat for that, and not the Solicitor General. And so I thought that to the extent there were changes like that, almost no reason to explain it. You explain it right there in the Federal Register.
That's a completely different thing, right?
Exactly.
If your client is changing their policy,
yeah,
then you just go along with what your client wants. Right. If there's a different EPA in town and the EPA has a different set of interpretations.
Yeah, exactly. And the other one, and sometimes it's unavoidable. I mean, if you have a position where it's, what's the administration's position on affirmative action or something, it may not be that there's really any regulation, and so you may just have to make that change. But I always thought one of the important roles of the SG's office was wherever it really was something that you could change through a regulation, that you tried to direct people. I would, not quite write down the address of the promulgating agency, but pretty much tell people, look, I'm happy to defend whatever regulation HHS comes up with at the end of the day here, but that's not really our call. And as long as this regulation's on the books, we're gonna defend it.
So I want to go back to Justice Kagan, because we're all rooting for you, and we're thinking about that first argument. Your first time in an appellate, was the first appellate argument at the Supreme Court, or did they warm you up in Poughkeepsie?
The first one was at the Supreme Court.
Okay.
Yeah, it was even worse than that. The first one was Citizens United.
Oh, wow.
Yeah.
The re-argument.
The re-argument of Citizens United, because it had been argued, and the last day of the term, the court had come out with an order saying, we're re-arguing this case in a special session, not in October, but in September. And then the court had ordered that the parties should focus their briefing on whether to overrule 2 cases, which basically meant everything's on the chopping block. So it was a big case. I think everybody kind of knew which way the wind was blowing. So I'm not sure that it was a case where I thought I was going to make all that much of a difference one way or the other. But it was nerve-wracking. I got up there. I went to the court the day before, because the day before was Justice Sotomayor's investiture, and the SG had been invited for that. I walked into the clerk's office, and the clerk gave me, can't understand why he did this, he gave me the thing that is on the justices' bench. When the justices come out on the bench, they have these papers in front of them which basically says who the advocates are. And I was arguing with 3 other people, and it was, I think it was me, Ted Olson, Seth Waxman, and Floyd Abrams. And what they give you is they give you a piece of paper that has like all your degrees on it, and then they have paper in the back which is all the arguments you've done at the Supreme Court. So I'm looking at this, it's just like page after page after page after page, and then it's like Elena Kagan, it's like one, So I was pretty nervous, yeah.
I would think so.
Yeah.
But it went okay, and you knew where to stand, and
I did know where to stand. I got up. It actually went fine. I got up. My heart was pounding. I thought, how am I going to get through this? I can't even hear anything. I got up. I said this. I memorized a few sentences to say at the beginning, and I said the first one. It was this completely anodyne statement about the history of campaign finance regulation. A sentence that I actually thought was fairly uncontroversial. And Justice Scalia leaned over the bench in this kind of way he had, and he yelled, I think he yelled it. He yelled, "Wait, wait, wait, wait." And then he asked me some question, basically told me that I was all wrong. But it was the best thing, it was the greatest thing that, he could have done for me.
He was trying to put you at ease.
Honestly, I think he kind of was. That he just wanted to sort of like get me in the game. And that was exactly what he did. It was like, somebody yells at you, you sort of start talking back, right? So
that's pretty great.
Yeah. But I lost, So it wasn't so great, really.
So, and then is there how many arguments, and is there also a scorecard so that the bench has, so they know what your record is?
No, they don't. They don't know that.
Oh, they don't. So, talking about Justice Scalia, so Paul, you argued before a justice that you clerked for, and I can remember watching Rex Lee argue before Justice White, and Justice White apparently thought that he was red meat, that he was still the justice, and he was dealing with his law clerk. And it was always a good show. Did you have that experience?
Very much so. Arguing in front of Justice Scalia and arguing to Justice Scalia, I think it's one of the great joys that a Supreme Court advocate had during the time that Justice Scalia was on the bench, because he really did sort of come at you in that, wait, don't finish that sentence, I have something for you. But in its own way, it was very empowering for the advocate, because there was nothing you couldn't say back to him. I mean, you could quip, he would try to make some laughter at your expense, but he accepted it if you pushed back in kind. And one of the things that was special for me is that was also exactly the way that he ran the clerkship. So he had, there's these debates about sort of justices' papers and, when should they be released and should it be 50 years, should they be destroyed, all of that kind of thing. In Justice Scalia's case, it won't really matter because it was an almost entirely oral chambers. I mean, he asked for a bench memo that was a page long. And really the highlight of the clerkship was what he called the clerks' conference. And you would go in there, all four clerks. One of the clerks was principally responsible for the case. But all four of the clerks were expected to go in there and talk about the case with the justice and answer his questions and push back and argue. And of course, there was no deference for his law clerks, to be sure. And it was the same way at oral argument, but it really was almost a continuation. Yeah. And I guess, whatever else you can say about him, maybe not in every case, not in a case like Citizens United, where he'd already thought about these issues quite a bit. I mean, one of the cases I think you were asked, whether they should overrule was the Austin case. And I argued a campaign finance case a couple of years before where I relied on the Austin case so much that Justice Scalia said, well, you really love that Austin case, don't you? So there's kind of reason to think that he had that in his sights. I mean, so he didn't hold anything back, but in a lot of cases, he was persuadable. I mean, he wasn't just asking the questions. They were hard questions, designed to be hard questions, but he was persuadable. And as an advocate, that's an awesome thing.
I should say that I did find one thing that it turns out you can't do back to Justice Scalia, but it wasn't that Justice Scalia set this rule. I agree with you. I loved my repartee with Justice Scalia, and because his questions were sometimes aggressive, but they were always totally straightforward and honest, and he wasn't trying to trick you. He was. And he always gave you a chance to answer. And so I loved the back and forth with Justice Scalia, and so much so that I became pretty comfortable with it. And we were going back and forth on one of, I think probably the least important case that I argued. But it was a hard case, it was complicated, and he was asking me questions, and finally I asked him a question. I was like, well, what would you do? I'm not sure exactly. And the Chief Justice decided that this was really beyond the bounds and said, that's not the way we do things here, General. But I have to say, I think Justice Scalia would have answered.
Yeah, I bet he would have. I think it's a good tactic. So, Justice Kagan, you also clerked, and your justice had passed away, Thurgood Marshall. But what did you take anything from that experience, that time as a law clerk, that you could draw on when you did become Solicitor General?
Well, the court in argument was an entirely different place then. I mean, it really did change when Justice Scalia came in, and Justice Scalia changed it. When he got to the bench, it was a pretty quiet bench. Every once in a while, somebody would ask a question. But if you look back at the transcripts from that era, it's just, I'm sure Paul now is maybe jealous of this. It's just page after page after page after page where they let the lawyer just talk. And, somebody would wake up at some point and say, what about this or that? But it was not this kind of constant barrage of questions. So, and it was really Justice Scalia who changed it. Justice Scalia came in, he started asking questions. There's a famous story where Justice Powell leaned over to Justice Blackmun and said, do you think he knows that the rest of us are here? But what happened was that as other justices came on, everybody thought, well, why does he get all the airtime, right? And it became kind of the thing that everybody wanted to do and thought should happen. So the arguments were really different. I did take from my time with Justice Marshall one really important thing to the SG's office, because if you said to Justice Marshall, what was the greatest job you ever had? Justice Marshall would not have said being being an Associate Justice of the Supreme Court, and he would not have said the greatest job I ever had was, doing justice at the LDF. He would have said the greatest job I ever had was being Solicitor General. And that he, in fact, would tell this story about how meaningful it was to him to go up to the podium, and whether in so many words or not, to essentially sort of think, I'm Thurgood Marshall and I'm representing the United States of America, and what an extraordinary thing that was for him. And of course, I just think thinking about that, thinking about how important the office was to him, just made me want to sort of do right by the office and do right by his memory.
That's very moving. That's really, really lovely. What was do you remember the hardest question? You got a question and it just stunned you, and maybe it came out of left field, or maybe it just was such a good question and you hadn't thought of the problem that way, you stayed up later that night thinking I should have said. Did that ever happen?
There are definitely times where you'd think after an argument, oh, now I know. Now I know what I should have said in response to that question. I definitely had arguments where there were questions that just kind of came out of either left field, or I guess the other dynamic that I saw a couple of times is, sometimes you're so ready to argue a case at a certain level, and you can almost, in some ways, the hardest arguments are where the justices are kind of with you on the first 3 steps of your argument, such that now the whole argument's going to be on your 4th step, which you didn't ever think about the case that way, and you really weren't prepared to spend 30 minutes talking about just the 4th step of the argument. You were really, hoping to score some points and gently get them to the 4th step, and then not have to talk about it too long, because that, maybe wasn't all that great. And so those were the arguments, I think, that were probably the most challenging arguments.
Any bloopers?
I don't know that there were too many bloopers. At least I hope not.
Yeah.
I mean, one of the great things about the SG's office is how well prepared people are when they finally step up to the podium, because you have the most amazing lawyers helping to prepare you, thinking about what should be in the briefs, thinking about what the basic argument should be, and then mooting you. And the moots are taken extremely seriously in the SG's office. And people, really read everything and think about everything and come in with their hardest questions and come in with the questions that they think Justice, X, Y, or Z will ask and Justice A, B, or C will ask. And it's pretty unusual, actually, that somebody does something where you think, gosh, I've been through 2 moots and I've thought about, and that was the killer question and nobody asked it. I mean, it just doesn't happen.
Yeah, no, and I think, to the extent, and this really, I think, gives you a sense of just the way the office works and the way the office sort of thinks about its mission. But if there is an argument like that, if an assistant gets up there and gets asked a series of tough questions that the moots really didn't prepare them for, the whole office kind of feels like they let the lawyer down. It's never that assistant let the office down by not giving a great argument. It was like, wow, something in the moots, we messed up. We didn't see sort of that angle. But as you said, it very rarely happened. And the other thing just about the moots, and I don't know if this was your experience too, but I was really both surprised and impressed by how often the government's theory of the case would change materially during the two or three moot courts you'd have in the SG's office. I mean, you tend to maybe think, especially when you're on the other side of the SG's office, as kind of being a little bit of a monolith where, you know, they've taken these positions and they must be incredibly thought out by the time the brief comes out. But in a Supreme Court case, you can usually write a brief that doesn't actually answer the two or three hardest questions, and you kind of leave that for the moot process and the oral argument process. And I was just surprised how much sometimes the answer at the argument in front of the court was maybe the answer at the second moot, but not the answer at the first moot.
Well, that's very interesting. So we have some questions from the audience, and we prefer questions that have smiley faces on them. This one's for Justice Kagan, and it says, "My name is Margaret, and I'm 11 years old. Did you know that you wanted to be a judge or Solicitor General when you were 11 years old? And can I meet you?"
Is Margaret here?
Presumably, Margaret. Stand up and be counted. Okay.
Hello, Margaret. Gosh, I didn't really know I wanted to be a judge when I was 11 years old. So if you do, it's very precocious. But it's a good job, so I encourage you to stick with it, you know. Work hard, do your best. And I guess we've now met, yeah? All right, so maybe we can meet again after.
So how about you, Paul? Did you know you wanted to be Solicitor General when you were growing up in Wisconsin, or were you dreaming of a major league curveball?
Yeah, no, I think, yeah, shortstop for the Brewers was probably where my head was at.
Yeah, I'm thinking so. Okay, so...
How about you, David?
When I was 11 years old, I don't know, probably wanted to write fiction or something, and that's pretty much what I've done. So, what advice do you have for students considering a law degree? I'm not sure the age of the question, but anyway, there's no smiley face. Advice to students considering a law degree.
Well, I'll start, which is just, you know, my advice to anybody thinking about a law degree is think long and hard about why you want to get this law degree. And if you have a good reason, by all means do it. I mean, I think you can have a wonderful career in the law, but I think the people in law school I knew who were the happiest were the ones that were most sure of why they wanted to be there. And I think one of the things I've noticed, I teach at Georgetown as an adjunct, and one of the things that's kind of interesting about what happened to the legal economy in 2008 and 2009 is I thought it made the students better, because I think the students that were in law school in 2010, 2011, 2012 were absolutely sure why they wanted to be there, because the economy sent them a signal that you just can't go there because you don't know what's next. So I think that, to me, that if you know why you want to go, it's a great degree to get.
You know, I used to, every year we would have these admitted student weekends at the law school I was dean at, you know, where all these people would come and you would talk to them about whether they should go to law school and whether they should go to this law school. And I always used to say something along the lines of what Paul just said, which is, you know, you should know why you want to be here. You shouldn't be doing this just because you can't think of anything else you want to do and you want to keep your options open. And that it did strike me someplace along the line that I went to law school because I couldn't think of anything else I wanted to do. And I wanted to keep my options open. So I had a little bit of cognitive dissonance about that. I think it's mostly right. The other piece of advice I always used to give to law students, and this one I don't feel conflicted about, was I think too many people, they get to law school and they just do what everybody else is doing. And they follow this path that just the one that everybody else is following, so it must be right. And it turns out there is no such path that's right for everybody, and often the thing that everybody else is doing, they're just doing because they don't have the imagination sufficient to look elsewhere. And so I always used to tell people, take risks, think about what you really want, try to figure out what moves you to get up in the morning. Because if you're just doing what everybody else is doing and for no better reason, that's a recipe for unhappiness.
Yeah. So I'm going to ask one more here. How do you maintain normalcy in your life when you are entrusted with such heavy responsibility that would keep most people up at night? Keep most people up all night.
Gosh, this is very bad. I'm going to go home. I'm not going to be able to sleep after this.
How do you maintain normalcy? So.
Yeah, who says I do?
That's true.
I think you have to be a good decider in this job. I think you also have to be a good decider as SG. I mean, one of the things we haven't talked about is SG, but you have to make constant decisions as SG. 4 or 5, 6 times a day, there's a big package of materials that comes to you, and you have to say appeal or not appeal, seek certiorari or not seek certiorari. And you hopefully you have great people working for you, and they give you good recommendations, but you're just having to make decision after decision after decision. And so if you're a good decider, it really helps to do the job. And I find the same thing is true of being a judge. At a certain point, you have to be able to say, I want to take in as much as I can. I want to work as hard as I can. I want to think about the arguments as long as I can. But at some point, I'm going to have to decide. And then I'm going to decide, and I'm not going to look back, and I'm not going to think about, all the regrets I should have.
Paul?
Well, I'd be interested how you think about it being different as the deciding role you have now versus in the SG's office. I mean, in a sense, I think the SG's office, the one thing it has going for it is you have so many decisions to make that, if you were sort of paralyzed by decision making, you'd end up with the Laverne and Shirley problem of things crashing on the floor very quickly. And in a way, I think it almost makes it easier because you can't spend too much time on every one case, because you really do. I mean, you run the numbers, you make something like 2,000 appeal decisions a year, so you just can't be paralyzed about those decision making. But in your current job, you're making...
Are you suggesting something about our caseload?
Well, I could. No, I'm just suggesting that you have more or less unlimited time. I mean, you can add time to the process if you want to. I mean, and fewer decisions. Does that make it harder, easier?
Yeah, harder. But at a certain point, time runs out. And
that's what the end of June is for.
Exactly.
It will end. You both seem rather normal, actually, but incredibly brilliant as well. And I know, on behalf of everybody here, thank you for your service to the country. Thank you for being with us here tonight. We really appreciate it.